Welcome to TP Law classes, and it is my request to all viewers to please like, share, and subscribe my channel. So, in this class, we will discuss regarding the very important concept which is we found in the preamble, and that is justice. So, we'll discuss the social justice, economical justice, and political justice in relation to explain what is exactly justice means. So, as it is enshrined in the preamble, social and economic justice are to be discussed in this class. So, the very first one is right to equality, and that is relating to both social, economic, and political justice. As we know, to bring an egalitarian social order, we have to eliminate and to eradicate all kind of social inequalities, social economic inequalities, and the very idea of exploitation, and to bring an social and economical equal status and opportunity to be provided among all the Indian citizens and individuals, those who are inhabitants of the Indian territory. So, right to equality as provided under Article 14 to 18, it deals with social equality, economical equality, also political equality. As if you analyze the very provisions of Article 14 to 18, so Article 14 express equality before law and equal protection of law. And Article 15 expresses that there should not be any discrimination among the people on the grounds of age, religion, caste, race, creed, sex, or place of birth. And so also Article 16 provides equal opportunity to all in public employment, and Article 17 provides abolition of untouchability, and Article 18 provides abolition of titles. So all these provides that there must be rule of law, and that rule of law reflects that no one is above law. So all are equal before law, and everyone should be treated equally. So also regarding equal protection of law, those who are in the same position or in the same profession, they must be equally treated among themselves. And as regarding Article 15, and there should not be any discrimination on the ground of religion, caste, creed, sex, or place of birth. And here it actually regarding there should not be discrimination as relating to scheduled caste, scheduled tribe, or other backward classes, women and children, and also regarding equal opportunity in public employment as provided under Article 16. It provides protective discrimination, which is reservation in public employment regarding scheduled caste, scheduled tribe, and other backward classes. And as per Article 17, it provides abolition of untouchability, and regarding that, the state enacted the Untouchability Offence Act 1955, and which was renamed in 1976 as Civil Protection or Civil Rights Protection Act. And as regarding all this, we found the very objective to achieve social and economical justice, also political justice. And as regarding Article 19 and Article 31, that under Article 19, the very provision of the freedom to acquire and hold property, and as regarding Article 31, which was a fundamental right, that is right to property, and these two provisions of the constitutions were removed from the very constitution under 44th Constitutional Amendment Act 1978 to bring equality in the very field of equality of status and opportunity. And now we'll analyze the very idea as portrayed under Article 23 and 24 of the Constitution, which is regarding right against exploitation. So, right against exploitation as provided under Article 23 and 24. So, it provides that there must be necessary steps to stop forced labor, child labor, bonded labor, and migrant workers, and immoral traffic and women and children. So these are the two articles which provides right against exploitation, and it could enable to bring an egalitarian social order where there would be no kinds of inequality, and there would not be any type of exploitation in the Indian society or state. And as regarding that, certain special directives are given to the state as in the form of directive principle of state policy to bring an egalitarian social order where it would remove not only poverty, illiteracy, ignorance, it would also bring social, economic, and political development of the Indian society. So we will go to the very provisions of directive principle of state policy as under Article 38 of the directive principle of state policy. It clearly emphasizes that the state must bring justice in the field of social, economic, and political aspects in the society, and also Article 39, which provides that the state must made it possible for adequate livelihood to all, and Article 39A, that is regarding free legal aid to all poor, illiterate, ignorant, and the backward classes of the society, and this provision of Article 39A was inserted into the directive principle of state policy under 42nd Constitutional Amendment of 1976, and Article 40, which provided that the state must bring the very institution of Panchayat Raj into the Indian society, and as provided under Article 40, so according to the very direction, the state or the Union of India constituted a Panchayat Raj committee under the chairmanship of Dr. Balwant Rai Mehta in 1956, and the very recommendation of Balwant Rai Mehta committee for introducing the three-tier panchayat system in India, which was implemented in 1959, and the very institution of Panchayat Raj was first inaugurated by the then Prime Minister Pandit Jawaharlal Nehru in Rajasthan in 1959, and subsequently it was again inaugurated in Andhra Pradesh in the same year in 1959, and now we'll go to the provisions under Article 41, which provided right to work, education, and public assistance, and this direction is given to the state to made it possible to provide everyone the right to work, education, and public assistance to those who are the needies and those who absolutely need the work and assistance in the nature of public assistance from the union or from the state regarding education, work, and in other fields, and Article 42 has directed the state to bring legislations to determine the very conditions of work and maternity relief, and in relation to that, state enacted many labor legislations or amendment to the existing labor legislations like the Industrial Dispute Act 1947, the Factories Act of 1948, so also under the very provision regarding maternity relief, the state enacted the Maternity Relief Act of 1961, and as regarding Article 43, it directs the state to make it possible for workers' participation in the management of factories and industries, and so also to implement and to bring cottage industries into the rural Indian society to provide equal opportunity in the field of employment and to remove poverty and illiteracy, ignorance among the rural mass. So, these are the provisions which are placed in directive principle of state policy as directions to the state, and so also Article 45, which also directs the state to provide and to bring enactment for providing free and compulsory education to all children in India. And as regarding Article 46, it directs the state to bring legislations and enactments regarding the educational and economic interest of the scheduled caste, scheduled tribe, and backward classes to bring to them to the actual fold of the society to achieve socio-economic and political equality as it is aimed under the preamble. So also Article 47 of the Constitution emphasizes that the state must work for to raise the very standard of living of the people in India, and Article 48 provides that the state should bring legislation and enactment to increase agricultural production and development in the field of agriculture, animal husbandry, and environment. So, in light of to implement the very directions under Article 48 of the Directive Principle of State Policy, the union or the state bring the very green revolution, and in the field of animal husbandry, it works for operation of flood, which is otherwise called white revolution, and the very green revolution was started in 1960s in Punjab under the very initiative of Dr. M.S. Swaminathan, and the very idea of operation of flood, which is otherwise called white revolution, was initially started with the help of the veterinary scientist and Dr. Varghese Kurian of Kerala. So, all these articles and lastly, all these directions of directive principle of state policy enables the state to bring out and to enact legislation to achieve all these objects which are inserted under the very directions given to state as directive principles of state policy, and to practically to implement all these directions, the state implemented certain schemes like NRGA and National Rural Employment Program and PDS, the Public Distribution System, the Indira Awas Yojana, and the Jawahar Rozgar Yojana, food for work, sanitation, public water supply and National Rural Health Mission and National Urban Health Mission, the Anganwadi, and giving all the children on polio, MDT, and all incentives on delivery to mothers, etc. So also many such programs were launched by the state to bring an equal social and economic order by removing or eradicating social and economic inequality and exploitation. And for that also the Union started Community Development Program in 1952, National Extension Services in 1953, and family planning in 1952. And regarding family planning, India was the first country in the world to implement and introduce family planning. And also India enacted the Food Adulteration Act in 1954, also started the National Water Supply and Sanitation Program in 1954, also the very constitution and establishment of Panchayat Raj in 1959. As already we have discussed, the very committee which was formed under the chairmanship of Dr. Balwant Rai Mehta in 1956, which the recommendation of Balwant Rai Mehta committee was implemented in 1959 through the first three-tier Panchayat Raj system was implemented in Rajasthan, and subsequently it implemented in Andhra Pradesh in the same year in 1959, and the first one was inaugurated by the then late Prime Minister Pandit Jawaharlal Nehru in Rajasthan. So also many amendments were made to the existing labor and industrial acts, and the state also enacted Maternity Relief Act of 1961, also Untouchability Offence Act of 1955, which was renamed as Civil Rights Protection Act in 1976, and also some other provisions of the Constitution which relates to the very idea of socio-economic equality and to remove inequalities. So, regarding that, as we found under Article 330 of the Constitution, there must be reservation for the people or the community of scheduled caste, scheduled tribe for an equal representation in the Union Parliament, and Article 32, which provides representation to scheduled caste, scheduled tribe communities into the state legislatures, and Article 335, which provides them to be provided reservation in the field of employment, and Article 338 provided for constitution of a commission relating to the scheduled caste and scheduled tribe, and Article 338 which refers to constitution of a commission, National Commission for Scheduled Caste and Scheduled Tribe, shall show Article 338V, which provided for constitution of a national commission for backward classes. So these are the constitutional provisions as we found in relation to bring social and economic justice as it is aimed in the preamble, and now we'll discuss certain important leading cases like the first one, State of Uttar Pradesh versus Ram Sanjeevan in 2010. The Supreme Court expressed that it is absolutely imperative to abolish the caste system as expeditiously as possible for the smooth functioning of rule of law and democracy in our country. And the second important leading case, Harjinder Singh versus Punjab Warehousing Corporation, and the case was decided in 2010 by our apex court or the Supreme Court. And an equal important case relating to that is official liquidator versus Dhanand in 2008, and it was also decided by the Supreme Court, and as they held that the approach of courts must be compatible with constitutional philosophy of which the directive principle of state policy constitute an integral part of the Constitution of India. So, all these that we have discussed or explained in this class are related to social and economic justice and how to achieve the social and economic justice as it is being portrayed under the fundamental rights in the form of right to equality and right against exploitation, and all those directions or directive principles as portrayed under the very heading of directive principle of state policy as provided under part 4th of the constitution. And regarding that also, as the state of India took several steps for constituting different programs, different developmental activities and their implementation, and those two important leading cases that we discuss in relating to social and economic justice. One is State of Uttar Pradesh versus Ram Sanjeevan in 2010, and the second one, Harjinder Singh versus Punjab Warehousing Corporation 2010, and the third one, Official Liquidator versus Dayanand in 2008. So, the entire subject relating to social and economic justice as aimed at under the fundamental rights and the directive principle of state policy, and as how these were implemented by the Union of India and how they were being carried out by different programs regarding development and improvement of the economic social standards and to eradicate and eliminate and to remove social economic inequalities, exploitations, and ultimately to achieve and to bring an egalitarian social and economic order into Indian society and state.